Sir, court count session. Judge Wayne Kelly presiding.
All right, good morning. Welcome back. Please be seated. Okay, we're ready to proceed.
Just before we get to the evidence, are they putting the cell phone records in today?
Oh yeah, we have the issue of the cell phone records. Mr. Claypool?
1 second, Judge. No, we're not making that, Judge.
Well, we had agreed to a procedure to place those in the record with respect to the statements that were made in opening. I have to reassess that whole issue, I guess, because that's the way we'd agreed to resolve it. Do you have the records available for the state to put in a rebuttal?
I do, Judge, and I have a witness here. And actually, my thing is, because of the way that they did that and misrepresented how they were going to do it, I'm asking the state judge to reopen my case so that I can put it into my witness. Not even a rebuttal.
Okay. Defense?
You want my help to confer briefly for us to stipulate the records?
No. They're not being stipulated. They're coming in.
What's... Oh, so you need somebody to explain.
Absolutely.
Okay,
Absolutely. Somebody needs to explain to the jury those misrepresentations. Absolutely.
Okay. All right. Do you still want to confirm?
During closing, if you'd like, here the phone records is just going to be called. They call a witness if we're stipulating to its admissibility.
Not agreed, Judge.
Well, no, the potential problem, Mr. Rosenfeld, is just looking at the phone records may cause the same confusion that made you believe that there were more phone calls than there were. So what they want to do is put a witness on who would testify as to the record and then would identify the actual calls.
Your Honor, the only problem I have based on Mr. Williams' representation the court is he wants the witness to proclaim to this jury that I misrepresented the jury. And I don't think that's within the province of the witness to say that.
I don't think the witness can say that. I think what the witness can do is authenticate the records and can testify as to the number of actual phone call contacts between Mr. Shahadi and Mr. Dippolito. The witness can't characterize it in any way. Testify as to facts only. I'm assuming
That's me in closing, absolutely.
Yeah, in closing, you can make statements that you didn't hear evidence about 500 calls, you heard evidence of whatever the number is, but the witness certainly can't characterize it or make any statements to that effect.
And we don't have, I mean, unless the state has a certified copy of those phone records, and if they do, I'm not aware of that.
There is actually, I
Okay.
in the first trial, there's a full set of records and it is term certification along with the subscriber information to show that it's
Okay, I'm going to let the state reopen to place those records in, since the defense is not intending to put them in evidence. So I'll allow you to reopen your case for that limited purpose, is to put those records in. When do you want to do that?
Judge, I'll do that. I'm assuming that they have this one more witness and then they're resting, and then I'll do that right after they rest. He's reviewing the records right now.
Okay, so the one more, well, I don't know, you say one more witness, I haven't asked Ms. Dippolito whether she wants to testify or not, so I don't know about that yet, but I'm talking about one more witness that was listed and identified as an expert, correct?
I can do mine in the rebuttal case, Judge. We'll just explain to the jury that we're reopening for that limited purpose and.
Just to keep things moving.
Yeah.
All right. Are we ready to proceed with then presentation of evidence?
The state, I guess I should write it down, make the state's objection to the admission of their expert testimony.
Okay, well, I need to hear that before we call the jury up.
Case law that I had provided to the defense as well. Judge, I would point the court to Huff v. State 495 Southern 2nd 145. It lays out two factors in determining the admissibility of expert testimony. States, one, the subject must be beyond the common understanding of the average layman, and two, the witness must have such knowledge as will properly aid the trier of fact in its search for truth. That case is citing to Mills versus Red Wing Carriers, 120 Southern 2nd, 453, decided by the 2nd DCA in 1961. Huff was decided by the Florida Supreme Court in 1986. In Mills, the court said, when the facts are within the ordinary experience of the jury, the conclusion from those facts will be left to them, and even experts will not be permitted to give conclusions in such cases. Expert testimony is admissible only when the facts to be determined are obscure and can be made clear only by and through the opinions of persons skilled in relation to the subject matter of the inquiry. Consequently, the opinion of an expert should be excluded where the facts testified to are of a kind that do not require any special knowledge or experience in order to form a conclusion, or of such character that they may be presumed to be within the ordinary experience of men moving in ordinary walks of life. In Huff, they were seeking an expert to testify who was a retired police officer. The court found, or he was going to testify to the improper and inadequate processing of the crime scene, which I think is analogous to my understanding of what Mr. Williams is going to testify to. In that situation, I will concede that there is a difference in the fact that that expert in that case initially hadn't visited the crime scene or read any transcripts or reports. My understanding is that Mr. Williams had, although that expert then went back and did it prior to testifying. The trial court in Huff said that the testimony was not only incompetent due to the lack of knowledge of the facts, but also was irrelevant and immaterial, and the court found that there was no abuse of discretion. In Johnson v. State 393 Southern 2nd 1069, decided by the Florida Supreme Court in 1980, the court said that the trial court has broad discretion in deciding which subject matters an expert can testify to, and that decision won't be disturbed absent a showing of clear error. So it's a abuse of discretion standard. I also provided to the court two newer cases, Perez v. Bell South Communications, just 138 Southern 3rd, 492, decided by the 3rd DCA in 2014. And this case goes into the fact that 90.702 obviously governs expert testimony. And in this case, the court goes to page 4, Westlaw page 4 of the opinion. It says the admissibility of evidence, expert testimony is governed by 90.702. And it talks about pure opinion testimony, and that the legislator has, in 90.702, when they amended it, has adopted the standards under Daubert, which I know the court is very well familiar with, and has basically, in doing so, it says the legislator expressed its intent to prohibit in the courts of the state pure opinion testimony is provided to in Marsh v. Value. And it says expert testimony that might otherwise qualify as pure opinion testimony is expressly prohibited. And then finally, in Bunnan versus Matrix Initiatives, which is 197 Southern 3rd, 1109, decided by the 4th DCA, actually June 1st of this year, the court, in that situation, the plaintiff's expert regarding causation for what seems like a products liability case was excluded under Daubert, and the court said that it was pure opinion, and the 4th found that that was not an abuse of discretion. The state's argument to the court is that in this situation, everything that I believe their expert is going to testify to is, the fact that, in their opinion, Mohammed Shihada wasn't properly vetted, the CI wasn't properly vetted, policies and procedures weren't properly followed, and in fact, I'm sure the court recalls that there was quite an extensive amount of questioning and testimony elicited based on the failure to follow certain protocols, and they placed into evidence the policies and procedures governing confidential and informants and governing investigations. I don't think that it's not like a medical malpractice suit where, there's a doctor coming in to explain exactly how a body works or, that type of thing. This is not something that requires expert testimony. A juror can very well read the manuals that were placed into evidence and gather from those what's required. It's purely an argument issue on the defense's side of it. In addition to that, in this day and age, police misconduct is a prevalent issue across the country. I think it's a time where people don't blindly trust police. And I say that because it goes to...
Let me make sure I understand the breadth of your objection. It would have to be beyond common understanding. I guess your position is it's not beyond common understanding. Are you also objecting that it's irrelevant and immaterial? You cited the Huff case as saying that. Is your objection just that it's not of the type of testimony which is necessary to aid the jury's understanding?
I think
Is
that
it relevancy and materiality as to testimony on policies and procedures? I'm just trying to understand exactly what you're saying.
I think that if their argument is entrapment by the police and they're saying that the police were rushing into this investigation and did things improperly in order to entrap her, then I think that I would have to say that it is relevant to that defense. However, I do think that it's not something that's outside the general understanding of a layman. And I think that under Daubert, it is nothing more than pure opinion testimony. He's not providing anything other than, in his pure opinion, in evaluating all of these things, and in his years of, as both a police officer and now as a police expert, as he pulls himself out to be, that it is pure opinion testimony.
Okay. Mr. Rosen.
1 second. There's a couple issues. First of all, I apologize if I'm slow in distinguishing these cases this morning. I was provided with them about 15 minutes ago, so I haven't had time to thoroughly review them. A couple things. I would agree with the state that it is relevant, and the issue they have goes to weight, not admissibility. I would argue that it's not pure opinion testimony. It goes to the application of the facts to the law. Now, the state began by distinguishing or bringing up Huff v. State. And in that case, the police officer had neither visited the crime scene nor read the testimony or reports of the investigating officers. Here, Mr. Williams reviewed, I believe, all of the depositions, transcripts, reports. We gave the state a thorough list of everything they went through. So he has reviewed all the steps taken by the police officers in their investigation in this case. So that is distinguishable. He's applying the facts to the law. Secondly, and just reading some of the case law provided by the state, this is from Mills, when facts are within ordinary experience of jury, conclusion therefrom will be left to them. And even experts will not be permitted to give these conclusions in such cases. Opinions of an expert should be excluded where facts testified to are of a kind that do not require any special knowledge or experience in order to form a conclusion, or are of such character that they may be presumed to be within the common experience of all men moving in the ordinary walks of life. Where opinion is nothing more than speculation of an admitted non-expert on the issue involved, then it invades the province of the jury. Here, this isn't speculation. And proper police protocol, police officers' their duty of due diligence to perform in a certain way, to conduct an investigation in a certain way, is not common knowledge for a jury. I mean, this is an expertise. This is a police officer with 29 years of experience. He's going to testify to standard practice and procedure and how the facts and the investigation conducted in this case did not comply with proper police protocol, and how that can necessarily, affect an investigation. That is without question a specialty. That's an expertise. One moment, Your Honor.
Your Honor, respectfully, I don't mean to interrupt Mr. Rosenthal. I did want to add one point, and I apologize since he's covering this. But contrary to what Ms. Laurie is saying, one of the big issues in this case that Mr. Williams will speak to is the proper protocol for collecting, retaining, and preserving evidence. There's nothing in the police practices directives that have been admitted into evidence that speak directly to the issue on the following: that all conversations between the confidential informant and the suspect need to be recorded. That's not in any of these directives. He should be permitted an opportunity based on his 30 years as a senior detective handling sting operations to speak to that issue. That is the proper protocol. So it goes beyond the mere directives. And the whole theme in this case is this investigation lacked integrity. It didn't have integrity. And that's not something that's in these manuals, number one. And number two, that's not something a layperson can glean. That's like telling us that we have to prove our case through Alex Marino and Frank Grant. I mean, that's really not fair. So, based on what the court's inclined to do, I'll defer on further argument.
Just a couple more points, Judge. Our theory of defense is necessarily that the police conduct compromised the integrity of this investigation. And in order, that's our theory in order to establish that.
As I understand, I mean, cut you off, Mr. President. As I understand it, I want to make sure I'm clear on this, the state is not contesting relevancy.
I don't know how I could contest relevancy because of what their defense is.
Okay, so because there are different objections that can be raised to an expert witness, okay, so the state is not objecting to the relevancy or materiality of the evidence. The state is saying that the expert testimony, number one, is pure opinion.
Yes.
And number two, is not needed to aid the understanding of the jury because it is a matter within common knowledge. That's the test.
Yes.
So that's the state's, it's not a relevancy argument, it's not a materiality argument, it's an argument. The only objection you're raising is that it's pure opinion and that it would be unnecessary because it's not beyond the common knowledge and understanding of jurors. Am I stating, because I want to rule on what's being argued.
You are stating that correctly, and I would add to my argument in response to what Mr. Claypool said is that and I guess just to kind of further explain to the court what my argument is, there is nothing that this person offers that, and why I think it's pure opinion, is that there's nothing that he offers that can't be argued by the defense, even when they're saying, he needs to explain that everything should be preserved. I think that's a very easy thing to argue to a jury. You don't need an expert to come in and say, well, it's good police practice to preserve something. And they get in the jury instructions, part of the standard jury instructions on reasonable doubt is, a lack of evidence. So they have this built already into the instructions that are given to a jury. They can argue there's a lack of evidence. The state didn't preserve these. They didn't record these things for you. But there's not a need for an expert to come in and explain the police should report things.
I would just let me briefly respond, Your Honor.
I'm about to rule in your favor. You can if you like.
And I am not going to briefly respond, Your Honor.
Okay. If I'm only ruling on what the objection in front of me is pure opinion and beyond common understanding. I don't believe it's going to be pure opinion. He'll establish, under Daubert, you have to establish the basis upon which he's going to testify. I'm assuming if he testifies consistent with his affidavit, he'll establish the basis of his opinion. And I don't think it's necessarily going to be pure opinion. I'm assuming he's going to testify as to his education, training, and experience. And there, I don't think it's pure opinion. And beyond the common understanding, although I think some of the points that you're raising, Ms. Lawyer, are correct, that you can argue logically the lack of evidence is a problem. That's the standard reasonable doubt. It's evidence, conflict of the evidence, or the lack of evidence, and you can argue the lack of evidence creates reasonable doubt. The defense can't. I'm not going to argue that. But if the argument is that, it's beyond the common understanding, I'm not sure police protocol and practice is within the common knowledge. And so,
If I can, I guess then, if I got creative and crafted an argument that it's not relevant because of the fact of what I'm saying and taking my argument and contorting it to say it's not relevant because it's not something that's needed to explain to a jury.
that just gets back to where you were. I mean,
Right.
there's a separate relevancy objection, but that's not the objection that you're interposing. And so I'm not considering a relevancy or materiality objection. You've conceded that from your perspective, you don't think you could in good faith make an argument that it's not relevant material. So I'm not doing that analysis, but to kind of come back at it and say, okay, it's not relevant material because it's pure opinion or because it's not needed to aid the jury, that's just kind of re-arguing the second level that we've been talking about.
Well, I guess I'm saying I could say that it's not, when I'm saying that I think it's relevant, I'm saying it in the sense of they're arguing entrapment. And so they're arguing, to my understanding, they're arguing entrapment based on police misconduct and that it forced Muhammad Shihada into his actions, which forced the defendant into her actions. My understanding that that's what their argument is. And so I think that they're using this to further explain that position.
Okay, I
So
understand that. So you-
I think I could say it's completely irrelevant because it has nothing to do with the crime at issue, but I don't know.
I'm just trying to understand, that's not the...
Right.
My question up front was, are you taking the position that the evidence is irrelevant and immaterial, or are you simply taking the position that it's not the proper subject matter of expert testimony because it's not beyond the common understanding of jurors and it's pure opinion? And the argument I got was the second one. It's not my job to tell you what to object to. I'm just saying...
No, I understand. I
that-
really think that's the
If
bulk
that's
of it.
if that's the objection, I have to rule on that objection. And on that objection, I don't think it's beyond, well, I think it is perhaps beyond the common understanding of jurors' police practices. So I don't think I would exclude on that basis or on the pure opinion basis. So that's all I was asking. I was just trying to define what is the objection I'm ruling on. And the objection I'm ruling on is what you gave me.
I would say though on the pure opinion, if he's going to come in and testify that, without adding, well, this should have been, basically, to me, it would be pure opinion because he's coming in and saying, well, they did this wrong and I would have done this differently and I would, my experience, this is how this should have been done. That to me would be pure opinion.
Well, he'd have to, I haven't heard his testimony, so I don't know what he's going to testify. He would have to couple that with, based on my education, training, and experience, there is a proper protocol that's recognized within police practices. That protocol is whatever it is, and that protocol was not followed here for whatever relevancy that might have. But I mean, he would still have to testify in a manner consistent with the ability to render the opinion. And candidly, at this point, I don't even know what those opinions are going to be. I mean, I read the affidavit. I mean, you can't, it was prepared for a different purpose, the affidavit, but I'm just using it as a tracking device to assume this is the type of evidence he's going to present. If there's specific evidence that he tries to testify to that you feel is objectionable, you can, I guess, impose a contemporaneous objection and say that this is, either outside the scope of his expertise or whatever objection there may be. But again, I'm just ruling on what's in front of me. What's in front of me is whether or not it's beyond the common understanding and whether it's pure opinion. And on that objection, we have to overrule that objection. Okay. Okay, are we ready to proceed?
Yes, Your Honor.
Let's bring in the jury. right, Councilman, be seated. Welcome back, ladies and gentlemen. Hope you had a good weekend. I think we're ready to proceed. Defense ready to call its next witness.
We'd like to call Sam Williams.
Mr. Williams. You may proceed.
Thank you, Your Honor. Good morning, ladies and gentlemen. Good morning, Mr. Williams.
Good morning.
Are you a former police officer?
I am.
How long were you a police officer?
I'm a retired senior detective supervisor from the Los Angeles Police Department, where I worked for 29 years and 5 months.
So you've come in from California to testify.
I have.
And can you describe for the jury your background as a police officer with the Los Angeles Police Department?
Sure. I came on the department in 1974, went through the police academy. From there I went to patrol, did a year in patrol, with just a probationary period. Then I went to another patrol division, Hollywood division. Then from there I went to an administrative assignment, working Employee Opportunity and Development Division. That division was responsible for the recruitment efforts for LAPD during that time. After I left there, I went back to patrol, and I ended up going to working detectives in 1979, where I stayed in detectives until I retired in 2003. My detective assignments during my career, over 26 years, was dedicated to criminal and administrative investigations. I worked robbery, homicide, crimes against persons, juvenile, domestic violence, narcotics, to name a few. I also was an adjutant. An adjutant is aide to a commanding officer. At the divisional level in LAPD, in those days, we had 18 divisions. Now there are 22 divisions. Some areas they call them precincts, but in LA they call them divisions. I was also an adjutant at the staff level. The staff level was at the chief's level, where I was working detective services group as an adjutant, which had oversight of all the detective functions citywide. Also on the administrative side, I did a loan in internal affairs as well. In my final assignment on LAPD, I worked robbery homicide division, where I retired in 2003.
What was the significance of being assigned to the robbery homicide division of the LAPD?